It is very heartening to see people join, and today we are here to talk about the implementation of the new criminal laws that has happened. As we are all aware, three new laws have replaced the old criminal laws that were there. Bharatiya Nyaya Sanhita, which has replaced IPC, Bharatiya Saksha Adhiniyam, which has replaced the Indian Evidence Act, and Bharatiya Nagri Suraksha Sanhita, which has replaced the CRPC. There have been a lot of debates that have sparked about the challenges that are in front for the law enforcing agencies, the judicial officers, and the professionals also. So today's panel discussion, we are privileged to have our distinguished group of legal experts who will share their insights on the perspectives of the significant legislative reforms. Before we proceed ahead, I will just give a brief introduction about our panel. With us, we have Advocate Rishika Chahar. She's a dedicated advocate with expertise in human rights, civil, criminal, family, intellectual property, constitutional law, and corporate law. But she has over 4 years of experience in legal practice and 12 years for in corporate HR. And ma'am is well known for her fierce advocacy and commitment to clients. Apart from that, outside the courtroom, she volunteers with Bright Hopes NGO, which is positively impacting her community and people around her, practicing from Delhi, Gurgaon, and Haryana. Ma'am is committed to justice and integrity. So, very hearty welcome to you, ma'am.
Thank you. Thank you.
Along with us, we also have Advocate Tushar Ghate. He's a practicing advocate having expertise in the matrimonial cases, check bounce, and criminal cases. He has published many articles through the intention of spreading awareness and educate people about their rights and remedies and make them understand law in a very simple language. So we are very glad to have you with us. Before we proceed ahead with our questions and discussions about the new criminal laws, I would like all of us to see a short video about what Rest the Case exactly does.
Rest the Case is a legal aggregator platform, a one-stop solution for all services and information. If you have any legal troubles, want a legal service, or need to consult a legal expert, we can help you. Speak with our registered lawyers available in over 200 plus cities. To consult a lawyer, you can sign up or contact us. Click on Find Lawyer, and filter lawyers by specialization, location, or even PIN code. Get contact details of lawyers instantly and contact the lawyers on the website, call, or email. To speak to our team, call us at 928-429-3610 or drop us an email at info@restthecase.com. If you are not looking for a lawyer, you can browse through our knowledge bank to get legal tips, learn about laws in a simplified manner, and stay updated on legal news. That's not all. Check out our extensive library of document templates to access legal drafts. Just select the template you want, fill out your details, and download it to use. In case of any queries, contact us at 928-429-3610 or info@restthecase.com.
So that was all about Rest the Case. Now, coming back to our panel discussions, the first question that I have for our panelists is can you give us a brief update about what are the changes that we're seeing in the new criminal laws that have come in, all three included?
Well, as you know, previously, IPC, Bharatiya Nyaya Sanhita, previously it was known as IPC. Previously, it was having around 511 sections. Now it has been reduced to 358 sections. And eight new provisions are added to the Bharatiya Nyaya Sanhita, and 20 provisions are repealed, and 175 sections are amended. Certain changes are made to 175 provisions, and I just believe that whatever changes have been made to Bharatiya Nyaya Sanhita, it was like today's demand. And I think whatever is happening these days with gender-based crimes, including females, children, so those things were like very serious, and it required some sort of deterrence so that the crime rate it can be reduced. And like Bharatiya Nyaya Sanhita, I mean, previously also IPC was like fully exhaustive, but certain things were like extra in IPC, which was not required in today's era, as IPC was a very colonial law. So something was missing in IPC. So I think whatever changes like are made in IPC, it was the need of the hour. And I think the organized crime kidnapping, extortion has been it has been properly categorized as crime. And I think the uh, other things like the what you call it sexual intercourse by deceptive means, it has been made a serious offense. It stipulates very serious penalty. And snatching has also been introduced in a crime category. Snatching is now an offense. And attempt to suicide, it also stipulates penalty. And deceptive intercourse is also stipulates very serious crime. Deceptive intercourse by the means of false commitment to marriage, inducement of job, or hiding the identity. It is also a very serious offense in Bharatiya Nyaya Sanhita. So
Okay.
this is all about Bharatiya Nyaya Sanhita. And when we talk about Bharatiya Saksha Adhiniyam, which was previously known as Indian Evidence Act, previously it was having 167. Now it has been increased to 170 provision. One section is added in it, and it has given importance to electronic evidence. Now Bharatiya Saksha Adhiniyam has like tried to give importance to electronic evidence equivalent to paper evidence. It has also expanded the list of secondary evidence, and electronic evidence has given more importance. And one that's all with the Bharatiya Saksha Adhiniyam. And when we come to Bharatiya Nagrik Suraksha Sanhita, which was previously known as Criminal Procedure Code, so it has increased the power of police in terms of custody, in terms of bail provision. The previously, as per CRPC, the police custody was uh, up to 15 days. Now it has been increased to 16 and 90 days, which again reduces the chances of accused to get the bail. And that custody, it can be given in parts. And another very important provision of FIR in Bharatiya Nagrik Suraksha Sanhita. Now there is a provision for zero FIR. FIR can be filed anywhere without worrying about the jurisdiction. And like the proclaimed offender, previously there was no provision where the proclaimed offender, like they used to escape, they used to run from detention. They used to run, they used to run like they don't want to face the trial. So now there is a specific provision in which the proclaimed offender, the judgment can be pronounced in the absence of proclaimed offender.
Okay.
And also there is a provision where the property purchased from crime proceeding can be attached, and it will not follow under the money laundering act.
Okay.
And provisions like previously, the medical investigation is to be conducted in rape cases. So there was a particular category that only a sub inspector can initiate the investigation for a rape victim. Now, the any police officer, the word any has been added, which expands the provision of the investigation against the women related offenses. So it has increased the horizons for investigation in rape cases, and lot of good things has also happened, which will definitely, it will bring new life. The proceedings will, it will take less time, and time limit is also made mandatory in women related offense. Like the rape, in rape cases, the investigation is to be completed in 1 week, and the proceedings should initiate within 15 days, and report should be given in 1 month. So a lot of good things has also introduced, which definitely help to overcome the women related and children related offenses. And there is also a very good provision which I like the punishment will be death penalty if rape is committed against a woman, against a girl below 18 years. Previously there was no such provision. So, I believe the changes which has done in all the three important major criminal laws, it was really, it was required because of the changing needs of a society, because of the economic crime, because of the societal needs. So I believe the changes which has brought up by the government was required.
Okay, okay. So according to you, ma'am, it will basically help to speed up the proceedings,
Yes,
which
yes,
has
yes,
seen quite
definitely,
some lag in the system. And also,
definitely.
the changes that have been made are much in tune with requirements of today's crime and their nature and the
Right, right,
punishments.
right, right.
Okay, Tushar sir, would you like to shed some light from your end about the same?
यस ऑफ कोर्स। जैसे मैडम ने कहा अभी, जो लॉज अमेंड हो गई है, अभी जो न्यू क्रिमिनल लॉज आए हुए हैं, इट इज नीडफुल, आने चाहिए थे। बट वो जो आए हैं इंडिया में, वो काफी डिबेटेबल है कि वो कैसे लाए गए इंडिया में। ठीक है, कि उनका हाउ द अमेंडमेंट हैज टेकन प्लेस इन द पार्लियामेंट, वो दैट इज अनदर पार्ट ऑफ द स्टोरी। व्हाट व्हाट आई थिंक, देयर आर सर्टेन सेक्शंस जिसमें काफी ज्यादा लाइक व्हाट यू से पावर्स दी गई है पुलिस को, लाइक इंक्वायरी। इफ यू सी द सेक्शन जहाँ पे पेटी ऑफेंसेस के लिए द पुलिस हैज द पावर टू फर्स्ट इन्वेस्टिगेट द मैटर फॉर 14 days, एंड देन आफ्टर दे थिंक कि वो मैटर इज जेन्युइन मैटर, देन ओनली दे विल रजिस्टर द एफआईआर, और एल्स दे वोंट रजिस्टर द एफआईआर। ऐसा वहां पे है। बट प्रॉब्लम कम्स देयर कि पहले भी पुलिस एफआईआर लिखवाते नहीं थे। नाउ नाउ दिस सेक्शंस कम इनटू पिक्चर। हेलो, आई एम ऑडिबल?
Yes, sir, you're audible. Uh, I think there's some issue with his connection. Nonetheless, we'll move on. I'm sure he will be with us soon once he joins back. So let's say now that the criminal laws are seeing a big overhaul. Where, in a very layman's language, when let's hypothetically say that there is a case there's a criminal case in court, So,
Hmm.
what laws are would be applied now that there are two laws? Can we say when we say that it is replacing? How will that implementation be done? What is the kind of applicability of law that we are looking at from the court's end here?
Actually, it's a very debatable issue these days. Now, for us also, there is a lot of confusion in court, in district court, as well as in high court and supreme court. And certain matters are stuck because, like, everybody standing on a dice has to prepare ki which thing will going to apply. We are just carrying all the books all the time. But like as per our Indian system, generally these are like very old law, and whenever anything new is introduced in society or anywhere, it takes time to get established because already like there are so many proceedings in the court, in district court, in high court, and in supreme court, which are in process and they are already filed by like old laws, right? So you cannot immediately switch to the new laws. And as per our Indian legal system, we go by retrospective effect. If anybody has any benefit, we give that benefit from the back date. Rather, I mean, I believe ki all the benefits we can give from the back date, but if any disadvantage is there, it should be given in such a way that neither party should get affected. I mean, you can give in coming future, like the proceedings which are in old, which are with the old process, with the old laws, with old court fee. So you can't change those proceedings all of a sudden. But yes, the new filing provision, if we file any new case, it can be done with the new provision. And generally, certain courts in Delhi, they have started this practice. But it is a slow process. It will take time. And there is a very debatable interview of Indra Jaising. She is a very notable senior lawyer with Karan Thapar. So, Indra Jaising, she was also saying that already 83,000 cases are pending, and this new law and old law, they are overlapping each other. So definitely there is a kind of a chaos, confusion for lawyer fraternity, even for judiciary, how to take things in a proper smoother manner. So generally, because of the overlapping thing, definitely the less beneficial party will get some sort of benefits because of the things, the laws, they are not being fully implemented. And even we people are new. And in old laws, we know what are the consequences. But in new law, even we need to see ki what will the effect of the new law. So still things are in progress, and definitely I believe this may lead to some sort of pendency in cases, some sort of, not full, I mean, it will increase pendency. I
So,
believe.
so,
It
like
is
you
my belief.
said in the previous question, when we were discussing that this will, the implementation of new laws will make our justice delivery system a little faster than it was before.
Yeah.
But till this entire overall of between the old and the new act happens, we are still looking at a lag in the justice delivery system yet. Is that correct?
Yeah, some sort of confusion, I can call it. Some sort of confusion because whenever anything new comes, you take time to learn that, no? Because like we are very much well versed with old laws. So even the judges, they need to see sometimes the filing is done with the old provision. Then advocates are asked to you please refile because you're filing after 1st July. So it happens sometimes, like it is a mistake, slip of error, we can say. So it happens with both, with advocates as well as with judges.
And as you also spoke about the retrospective effect that we can get in. Uh, what how will the court be mostly looking at cases that were, let's say, in courts before the 1st of July, since 1st of July is the date that these laws were put into effect? How is the court looking at the cases that were filed before 1st of July or were in proceedings before 1st of July?
Actually, the cases before 1st July, like they are like running smooth at the same pace that they were like previously. They were like with the same pace. There is no change in the pace. But yes, the new laws, some sort of like even the clients who are coming to us, they are very much confused, ma'am. How will you going to file our case, and how much time it will take? And there is also issue like the printing of the bare acts, like the poor clients, the legal aid clients, they generally they are not in the condition to hire a lawyer, so sometimes they fight their case themselves by buying the books of by buying bare acts. There is also a shortage of bare acts. Uh, Booksellers are like very scared to purchase the new bare acts, and printing press also, they are just checking ki what's the demand for the new law, it will change or it will suspend. So some sort of uncertainty is there. But yes, filing rate filing rate has reduced because client, even they have a confusion, ma'am. This was not there in the previous law. Previously, snatching was not an offense, and now it is an offense. So even the investigating authorities, they are like IOs, and they do have some sort of query. So these days, like lot of passovers are being taken in the court also that I'm seeing because of uncertainty.
So as of now, we can say that the courts are looking at implementing both the laws side by side, like the
Yeah, yeah,
cases that
both
were
are
filed.
running simultaneously. Both are running in
So
district
like,
court, in high court, as well as in Supreme Court.
so how does what I want to know from you in a little detail is how does this let's say under the criminal laws a person is charged with an offense and it is proven in the trial. Uh, will the will the new laws, the new systems of punishment, will they be considered, or will the old punishments that existed will be considered? Looking at the reason for asking this is because the newer laws are focusing on a better delivery system, stringent punishments, betterment of the society. So, how will the punishment happen in case of a conviction?
See, punishment, it is a very, it comes at a very late age. And generally, whenever charge is applied, so charge is higher, and generally the punishment is less. So in that case, by giving the punishment, whenever any judge is giving a punishment, so he or she is always very thoughtful. They never give punishment on same particular day. They just keep a day for judgment, and then quantum of punishment is decided. So many factors, and those factors, those were considered previously, and even on the new laws, they are considering those factors. But the thing is that they just previously there was no provision like in joint trial, if anybody has absconded and if anybody is not present, so they used to delete the name of that person. But now, like in their joint trial, in section 24 of Bharatiya Sakshya Adhiniyam, it has increased the scope of section 24 for joint trial. So in that case, the judiciary, they see that who is at the benefit end, because our system says that like no innocent should get the punishment, and if any accused gets free, it is okay, but innocent should not be punished. So that
Correct.
is the system which is followed till date in all the courts in India.
Okay.
So I believe ki it will take time, and both the laws are going simultaneously. But yes, like this, previously there was no. I mean, VC was video conferencing was allowed in certain cases, but now they have allowed in majority of the cases. Mean the NRIs who are residing outside India, they can pursue their litigation very smoothly. Mean the NRI people, they are like filing cases very smoothly. They are getting proper electronic evidence, and judges are giving same sort of time. Proper things are given to them. So one major change what I have observed is that NRI litigation is now very smooth because electronic evidence recording, it has been made mandatory in all the proceedings. You can get electronic records in all the proceedings. I mean the previously there was less weightage used to be given to the electronics records. I mean there was more emphasis on the paper record, but now it is equal. So it also saves time and energy rather taking pile of papers and files. Even it is convenient for us to give the evidence on VC.
Right. So, when the new laws were implemented, like the news came out on, I think they joined by Tushar sir again. Uh, so we'll continue the discussion. Like I was saying, that when these laws came into force and it was declared in the news on 1st of July that new laws have been made applicable, there were a lot of people who came out and criticized its implementations and the provisions that were there. Uh, Critiques had said that police have been given a very increased power and their discretion, and there can be potential delays in filing of the cases. Like I think Tushar sir was talking about the same when it comes from a police perspective. So how do you think this will roll out?
Hello.
See, definitely the previously, like what I see that police has been
Hello.
given some sort of
Tushar
discretion.
sir, we can hear you.
Okay. Okay. Sorry.
So previously, like police was having a very less time in collecting the information, doing the investigation, because crime is such a thing. It requires lot of time. It has lot of stages, and the district court provision is very exhaustive. So police basically they were like struggling to complete the investigation. So coin has two faces. We see that the police will increase the atrocities. They will have more time to interrogate the accused. Sometimes even the innocent will be suffering. But at last, I mean, some sort of liberty is to be given to police. Reason being, otherwise they won't be able to do their job. Generally, executives' duty is to control the crime. So, if some sort of discretion has been given to police, I believe it will create a deterrence with the criminals. They will be scared, and I think the habitual offenders and professional criminals, the people, they have a very wrong notions about Indian legal system, about police. I believe people misinterpreted the powers of police. General rule is that police they do their job. There are exceptions. There are certain police officers who really misuse their power, but in total there are many landmark judgments of Supreme Court, of an High Court before implementing the new laws. They are being challenged by Supreme Court in their judgment. They have given so many warnings. You may take the you may take Dyuman Upadhyay case, custodial death, and there are cases in which the FIR is to be, I mean, any police officer, it's their duty to file the FIR, whether it's their jurisdiction or not. Like zero FIR provision is introduced in new law, but previously there was no specific provision for FIR, as well as FIR was not defined at all in CRPC. But this time they have given a special provision which specifies the provision for FIR. Previously in CRPC, only section 154 it talks about FIR, but still it does not define the FIR. So I think it's a check and balance. If certain power has been increased, so the court need to check on those parts, like whether police they are not misusing that power. So yes, a coin has two faces, so it's a check and balance. Mean one has to keep an eye on police as well, but by this it will reduce some sort of crime everywhere in India.
Okay, okay. Tushar sir, would you like to also add on to the point since you were already speaking about the same before you got disconnected? The
Yes, yes,
police,
yes.
the powers the police have been given. That's something that has been debated about very frequently.
यस यस तो वही प्रॉब्लम है अभी पुलिस को पावर दी गई है अकॉर्डिंग टू मी ठीक है देयर इज एक्सेप्शंस ऑफ सम पुलिस जो अच्छा लाइक दे आर रजिस्टरिंग एफआईआर एंड ऑल दे आर डूइंग अ गुड जॉब बट हियर कम्स अ प्रॉब्लम where the police has the discretionary power to register the FIR of
Okay.
certain offenses, not about serious offenses. About the offenses where punishment is less, where punishment is 3 years but less than 7 years, where the police has their directions to whether they can file the FIR after doing a primary inquiry about it. Okay, first part is there. Second part, what I want to highlight is that section 69 of BNS, which is again a debatable topic. Section 16 of 16 of a BNS, what it says, let me read it for you. It says sexual intercourse by employing deceitful means. Now, who will decide? Now, who will interpret the main deceitful means and who will interpret the word deceitful means? What will happen here now? The cases, this section itself is a hello.
Yes, we can hear you still, sir, but we can't see you. Hello, Tushar sir. Hello. I think he's still
Some
getting
glitches
disconnected.
there,
Yeah,
some
some
glitches there.
glitches.
He's trying to join, but
Yeah,
somehow
something is not working out. No worries. We will continue with our discussions. We are joined by Advocate Manan Mehra. So, a big welcome to you, sir. Uh, can you hear us? Uh, so,
Yeah,
uh,
hi. Am I audible?
Yes, yes, yes. So you're audible. So let me just give a quick introduction of Advocate Manan Mehra. He has his own practice. He's a distinguished practice based in Delhi in commercial and civil laws, and he is a person who also practices in consumer disputes. Although he has worked on a wide cases of spectrum uh, for all the legal cases across the country and keeping the clients first and ensuring speedy resolutions has earned Sir quite a distinguished reputation. So, a big welcome to you, sir. And
Hello, hi. Very happy to
yeah,
be here again.
we were discussing about the implementation of the new criminal laws that are there. I was just discussing with Rishika ma'am about the debates over the police provisions of the powers that have been given to the police in the new criminal laws. So, ma'am has shared her insights. Would you like to add on to that?
So, I mean, I did get a little bit of drift of the conversation, although I think it would be nice if we can start a specific topic if the early one is finished, so
So
that then I can contribute meaningfully. Otherwise,
Yeah,
I
so
think.
the question that we were discussing is that since the new criminal laws have been implemented, there are a lot of debates that were sparked and a lot of critiques coming out talking about certain provisions of the new criminal laws that could have a deteriorating effect. One of them was the powers that were given to the police in case of beat of filing of FIR. So critics were saying that this is going to increase the police atrocities and also maybe create a lot of pendency when it comes to filing of the cases. So we want to know from you, what are your views about this?
So my first critique of these laws is in the direction of the fact that there was no consolidated process that was followed while drafting them. We know for a fact that there was no discussion that went on in the parliament, and also know for a fact that there was no discussion that happened ever in the important bodies that exist for drafting and stakeholder discussion of law, like the law. Now, when we look at a law that is so made by the executive, one thing that we can be sure is that the executive will reserve for itself most of the convenience that it can, and that is what has happened. Uh, and answering the question, yes, in terms of registering of FIR, uh, earlier and even in the case of Krishna Kumari, the guidelines that have come from the Supreme Court and the law as it evolved, that it was compulsory for a police officer to register an FIR when a cognitive offense is disclosed. However, now after this, there's a wide amount of discretion that has been given again around preliminary investigation being allowed by the police officer and him being ascertaining his stand on whether a criminal case should be registered or not. This kind of a situation creates a lot of autonomy and a lot of discretionary powers in the executive, which is not the goal of the legislation or the law as it has evolved over the years. There has been a kind of sentiment coming that okay, this law is now very Indianized and this law is our own law and everything. But if we look at it from a objective point of view, it has always been our law. It is not like we have carried forward the same laws that the British enacted so long ago. And even the IPC, the CRPC, the Evidence Act, they went through such a huge number of amendments in the recent times, as well as at the time when they were adopted into an independent India's law. Because at the time of adopting them, before they were enacted as a part of the independent country's laws, everything was filtered out by the Law Commission, which was a remnant of the British era. In fact, Macaulay would popularly, it is been mentioned in the discourse, and I agree with that, that Macaulay would call this law his adopted child, which is the reason that 95% of the laws are exactly the same. The provisions that should have been shun out, like sedition, like provisions which actually required, uh, you know, an upgrade. It's also a debate around um, the marital aspect and um, the debate around affairs of a person with another person while being married being held a crime, uh, which required amendment. Now, these aspects which the present administration had a unique and golden opportunity to when it to address, and this opportunity does not arise for every government here and there. They had a unique opportunity to do something meaningful, which is very sadly not been done. Quite the opposite has been done, wherein a meaningless exercise of shuffling the sections has been done. Now, shuffling section numbers, it simply creates a lot of confusion for everyone involved in every legal process. For example, now every lawyer, every police officer, every lay person who at least had a few sections in mind that, okay, this murder is 302, this is that, cheating is 420, whatever. So now, even that minimum knowledge and where it has been placed in the code and what is said, it has now become a lot of confusion for them. Not everyone will have the patience and the time and the energy to go through the new law, find where this issue is there again, and then go ahead. It will create a delay at every step of criminal justice administration, which is a big problem. If the intention was to bring in 5% changes or here and there, maybe 10 new amendments, it could have been done by way of an amendment. Why reshuffle the entire law? Why, create a. So it is not like when you think of the backbone of the criminal justice system and you will think about laws, it is not that uh, it is for a reason of laziness or anything that countries continue with the same set of laws for a for an extended period of time, or they don't shuffle laws or um, adopt very major amendments without any consultative process. Anything, the law must remain stable for the people to trust in it. If tomorrow is today one law is applicable and a couple of years after that another law is applicable or it's given a new name, for the common man or for the people who we are making the laws, it becomes a very undependable kind of a process. How am I to live my life according to a set of rules if that set of rules can anyway be rejiggled by any government which comes in with the majority? So that is my input on this discussion. Thank you. You can continue.
So I think more it's going to complicate life for the common person to who these laws are made applicable to get a hold of what is exactly happening in the legal system and how the so uh, from what I could figure out that you were trying to say that this complete overhaul instead of this if changes could have brought in through a way of amendment it would have been better for its implementation and applicability as well. You also spoke about sedation. So, coming to my next question, there, charges of sedation has also seen a lot of overhaul, and it did prompt concerns about curtailing freedom of speech for individuals. So, how do you think that these laws that have been changed in the new act will, to some extent, curtail that common man's freedom of expression and speech?
So I mentioned briefly that sedition as a concept was um, the Supreme Court said that sedition should no longer be there in our criminal justice system, and it makes complete sense because criticism of the government is the reason that we have a government in the first place. We could not critique kings and emperors and dictators. That is why we have a government so that we can critique them. Now, sedition was outrightly nonsensical in that way that not allowing you to critique your government. So it was very rightly removed from the law by the Supreme Court. Now, with a very wide definition coming in, which basically is a blanket kind of a cover to include each and everything in it by the government. So when there is no strict interpretation of what national security is or what you know uh, is harmful to public order, etc., etc. These terms are very wide, and no strict interpretation can ever exist for them. Any and every act can be slid into them depending on what is the mood of the administration. So, for a very crucial right, which is freedom of speech and expression, we cannot have a law which is so open to interpretation. Obviously, we can trust that if there is some kind of a problem with interpretation and some blatant violation of rights, the courts will step in. But that process itself should not happen so easily. Like an interpretation which moves so many cases to the courts will create further problems and is will create a chilling effect on anyone who might have views which are not in line with the administration. The chilling effect itself, without any, there might not be prosecution, there might not be, uh, you know, I mean, we are imagining a doomsday scenario, but it might not be that way. Regardless of there not existing a doomsday scenario or there existing an Orwellian state of affairs, the law itself, when it does not protect you or your views, you are stopped even before you share them. So that is a chilling effect which can come in because of a law that does not offer sufficient protections.
Rishika ma'am, would you like to give your inputs on the same?
I'm like what I was feeling, Mr. Manan, Advocate Manan, they have said the same thing. I do agree with him that sedition mean basically it would have mean the our legal system they would have removed it like long back because it creates some sort of restriction on everybody because we are living in a democracy and we all have right to speak for the government and against the government. So if that right is curtailed, so we cannot express. And India is a like we are living in a free world. India is the largest democracy. So if anybody puts any kind of restriction on speech and expression, so definitely it creates some sort of it's a basically it's a uncomfort zone. I mean, we are not in a comfort zone because in democracy, freedom of speech and expression is the first and the foremost condition. And sedition, I believe, ki indirectly it also like restrict our fundamental right. So it's a kind of encroachment on our fundamental right. So I think this sedition would have removed long back. So this was a good move.
Okay, so basically it will prove beneficial, but we have a few questions from the audience that are coming in. Let us take one by one. So Ashish Patil is asking, how will the common people benefit from this law? So if the panelists would want to address it.
So I think it's a benefit in many way, like many female related offenses, like the strict. It is in many provision, like female and children, they have given protection. Like if any rape is, if any rape is done against a girl below 18 years, so it will lead to a life imprisonment. It could be death penalty as well. And secondly, it has also increased the ground for murder. And also, I told you previously that intercourse by deception, again, it stipulates very serious penalty. Previously, there was no such provision regarding deception, intercourse by deception. And again, attempt to suicide, it also stipulates the penalty. Previously, there was no like penalty for any attempt to suicide, and the investigation. All the medical examination is to be conducted in the offenses which will have like imprisonment more than 7 years. So I think certain changes are good, but yes, there is also a repetition. Simply they have changed the heading, and rest the content is same. So I think certain things are good and certain things are repetitive.
Okay. All right. So it will benefit, but again, we are looking at a time frame for that to start benefiting the public at large.
Yeah, like electronic evidence, it has given the importance equivalent to a paper record. So that is there. VC is included in almost all the proceedings. And there is also a time limit in rape proceedings, investigation in rape proceedings, and the medical examination of rape victim can be done. It has to be completed in 1 month, and in 15 days the process is to be completed, and in 30 days they have to give the judgment. So yes, the time limit it will also reduce the burden of the courts. They just give some bracket key as in certain time limit you have to finish the proceeding, definitely it will also reduce the burden of the court.
Okay. I would like Manan sir to address the next question. What should the public know about these changes? Is what Nitin wants to know from the audience. Uh, Manan sir, we can't hear you.
Yes, am I audible now?
Yes.
So, one more important provision I think for the public in general should be regarding the bail amendment that has been made. So, the new changes that have come in, one important unique point is that if more than one case is pending against you, bail will not be granted. The current legislation does not include a clause that would prevent an under trial prisoner from being granted bail in situations when an individual is the subject of an ongoing investigation, inquiry, or trial for multiple offences or cases. The new law, however, which has come in now and is active, has introduced a harsher clause that states that an individual facing an investigation, inquiry, or trial for more than one offence or in numerous cases would not be granted bail and will instead be placed in an under trial prison. Now, an under trial prison is basically police custody and is different from the jail, which is typically understood, which is judicial custody. When you are in an under trial prison, you are more prone to police atrocities than you would have been in a normal jail with judicial oversight. Bail may be granted based on the superintendent of jail's report. The new law features a clause requiring that the superintendent of jail file a written application to the court in order to proceed with the release of an under trial prisoner on bail after they have served one third or half of the statutory sentence, depending on the circumstances for the offense. So, a superintendent of police actually has no role in judicial interpretation of whether or not a person should be granted bail. A person of the rank of a of a superintendent of police should have no role in determining whether or not a accused person, can be released or not. This power is a judicial function, not an executive function. So this creates a lot of, you can say, discretionary powers for the police, which is not an ideal situation. I mean, others, what we've mentioned is that uh, the digital recording of evidence that has been done is a welcome move because earlier a lot of cases were delayed because the persons who were supposed to give evidence cannot travel to the jurisdiction, and so on one day someone is not coming or other someone is not. So that is a welcome move that due to technological advances now digital recording of evidences is allowed. And further, I think the new public should try to get to know the new law as the sections are shuffled. So if they're probably in a situation, they can easily ask for help or communicate at least the they're charged with. Someone can come up with so that.
Okay. So, thank you. So, I think we have had quite an in-detail discussion about the new laws. I'm sure that it is yet not enough. In everyone from the legal fraternity has a lot of inputs and thoughts about the new laws in the comparison with the old laws. So, I thank the panelists again for sharing their insights. I'm very sure our audiences must have gotten at least a gist of how the Indian legal, especially the criminal system, looks like from now. So I will now request the panelists to extend their closing notes if they have any.
Sorry.
Rishika ma'am, I would
Okay.
request you
I think
to give any closing notes if you have any on today's panel discussion.
Well, the discussion I had, I really enjoyed discussion having with you and all other panelists who were there on the panel. So This was my first experience with the REST case, and it was my first panel discussion. So I really enjoyed it, and I hope in future when I'll be given the chance to express myself. But if we consider the changes made in the new law, I think the women and children, they have given protection, and including all the electronic records. I mean, the use of electronic records has been increased. The issue of jurisdiction in filing the FIR, it has reduced. Definitely, uh, these things will give benefit to the common public, because getting the FIR registered because of jurisdiction, it's a very common problem which is faced by each and every individual sometime in their life. So I think this jurisdiction problem has been solved up to some extent. And previously, there was no specific provision for terrorism. Now they have also introduced terrorism. So that again, it's a big benefit, because terrorism is a national threat. It's a global threat. So previously, terrorism was not defined anywhere in any law. So whatever definition has been given to terrorism, it is as per the UN terrorism definition. So I think again it's a big change which was required in today's society, because terrorism again it's a very big problem for each and every nation.
Thank you, Ruchika ma'am, for your closing notes. Manan sir, do you have any closing notes for us?
No, no, I think we covered everything.
Uh, all right. Thank you so much. It was very nice to have you both on the panel, and it is always fruitful to have discussions about the upcoming changes. And the legal system is always, now it has started to be more dynamic. So I think we will definitely have a lot of discussions coming up with you as a panelist. So I also extend a very big thank you on behalf of the team Rest the Case to our panelists and the audience also. I just want to inform that the video of the same is available on YouTube channels of Rest the Case. Your audiences can view it later also if they need. Thank you so much, and have a good day.
Thank you.
Thank you.